Dear learners, welcome once again to the interesting aspect of this course, the International Humanitarian Law. Let us begin with today's topic of prisoners of war. One of the major objectives of IHL is to protect victims of armed conflicts. Prisoners of war or PWs is another major protected group under IHL. This category of victims are combatants who are no longer taking part in armed conflicts because of being captured by the enemy or surrendering to them. The lecture defines the concept of PW and takes the students further into the detailed provisions of the protection of PWs under IHL. After this lecture, you should be able to understand who is a prisoner of war, treatment of prisoners of war, transmission of information and monitoring, and repatriation of prisoners of war. Who is a prisoner of war? The status of PW only applies in international armed conflict. PWs are usually members of the armed forces of one of the parties to a conflict who are or they and fall into the hands of the adverse party. The Geneva Convention 3rd and the Additional Protocol 1 also classify other categories of persons who have the right to PW status or may be treated as PWs. Provisions of International Humanitarian Law or IHL prohibits PWs from being prosecuted for taking a direct part in hostilities. Their detention is not a form of punishment but only aims to prevent further participation in the conflict. They must be released and repatriated without delay after the end of hostilities. The detaining power may prosecute them for possible war crimes but not for acts of violence that are lawful under the IHL. PWs must be treated humanely in all circumstances. They are protected against any act of violence as well as against intimidation, insult, and public curiosity. IHL also defines minimum conditions of detention covering such issues as accommodation, food, clothing, hygiene, and medical care. Hors de combat. Hors de combat is a French term used in international law, literally meaning outside the fight, to refer to military personnel who are incapable of performing their military function. Examples include fighter pilots and aircrew members parachuting from an aircraft in distress, as well as the sick, wounded, detained, shipwrecked, or otherwise disabled. Military personnel who is a hors de combat is normally granted special protections according to the laws of war, including prisoners of war status. In addition to personnel hors de combat may refer to anything out of action or disabled. Additional Protocol 1 defines a person is hors de combat if A. He is in power of an adverse party, B. He clearly expresses an intention to surrender, or C. He has been rendered unconscious or is otherwise incapacitated by wounds or sickness and therefore is incapable of defending himself, provided that in any of these cases he abstains from any hostile act and does not attempt to escape. Combatant status and PWs. As in the case of wounded, sick, and shipwrecked, we discussed in Module 3, the Geneva Convention identifies PWs also on the basis of combatant status. An enemy combatant in an international armed conflict can be attacked irrespective of time and circumstances. This is true until they cease to be combatants, retire from military service and become civilians, or gain immunity from attack by becoming hors de combat through surrender or incapacitation. The very essence of PW concept is that combatants have the right to engage in armed conflicts and they should not be penalized for the same once they stop fighting. Further, once they are no longer taking part in armed conflict, they should be protected. A combatant who is an hors de combat and falls into the hands of the enemy is entitled to the privileges of a PW. However, The privileged status of a PW is lost if the captured person is an unlawful combatant. The distinction between combatants and unlawful combatants is very important in this protection regime under IHL, because it is a corollary to the distinction between combatants and civilians. A civilian who takes part in hostilities will lose his protection and can be attacked by the enemy combatants, and once captured, such civilians are not entitled to PW status. Following are the categories of persons, if captured by the enemy combatants, are not entitled to PW status and will be considered as unlawful combatants if they were involved in the conflict. A civilian taking part in hostilities, spies according to Article 46 Additional Protocol 1, mercenaries according to Article 47 of AP1. More than denial of PW status, the other consequences of unlawful combatant status include automatic detention, unlike a civilian, and liability to be prosecuted and punished by military tribunals for taking part in the conflict. It is worth noting that a PW cannot be prosecuted for taking part in the conflict as he is a lawful combatant. However, a PW can be prosecuted for war crimes committed during his lawful combatant's role. Hence, there are differences between prosecution of a war crime and that of being an unlawful combatant. Who is a prisoner of war or PW? Article 4 of Geneva Convention 3rd and Article 44 of the Additional Protocol 1 define who is a PW. As per Article 4 Clause A of Geneva Convention 3 or GC3, PW is a person belonging to one of the following categories who have fallen into the power of the enemy. These are members of the armed forces of a party to the conflict, as well as members of militias or volunteer corps forming part of such armed forces. Members of other militias and members of other volunteer corps include those of organized resistance movements belonging to a party to the conflict and operating in or outside their territory, even if this territory is occupied, provided that such militias or volunteer corps, including such organized resistance movements, fulfill the following conditions: that of being commanded by a person responsible for his or her subordinates, that of having a fixed distinctive sign recognizable at a distance, that of carrying arms openly, that of conducting their operations in accordance with the laws and customs of war. Members of regular armed forces who profess allegiance to a government or an authority not recognized by the detaining power. Persons who accompany the armed forces without actually being members thereof, such as civilian members of military aircraft crews, war correspondents, supply contractors, etc., if hold an identity card issued by the state party to which they belong. Members of crews, including masters, pilots and apprentices of the merchant marine and the crews of civil aircraft of the parties to the conflict, who do not benefit by more favorable treatment under any other provision of international law. And levy en masse, that is, inhabitants of a non-occupied territory who on the approach of the enemy spontaneously take up arms to resist the invading forces without having had time to form themselves into regular armed units, provided they carry arms openly and respect the laws and customs of war. Article 4 Clause B goes on to create two other categories who should be treated as PW, one relating to the members of the armed forces who have been released from detention in occupied territories and are then re-interned, and the other pertaining to members of armed forces of the belligerent parties who reach neutral territory and have to be interned there under international law. Article 4 Clause C exempts the medical personnel and chaplains as provided for in Article 33 of Geneva Convention 3, as this article will in no way affect their status. Article 43 of the Additional Protocol 1 or AP1 lays down that armed forces consist of all organized armed forces, groups and units which are under a command responsible to that party and shall be subject to an internal disciplinary system which, in compliance with the rules of international law applicable in armed conflict. It further lays down that the members of the armed forces to a party, to a conflict, other than medical personnel and chaplains covered by Article 33 of the Third Convention, are combatants and have the right to participate directly in the hostilities. Article 44 of AP1 defines PW as any combatant as defined under Article 43 who falls into the power of an adverse party. It further mentions that violations of international law applicable to armed conflicts by a person shall not deprive him or her of combatant or PW status. However, if a combatant does not distinguish himself or herself from a civilian during a military operation as per this article, that is, carry weapons openly, shall forfeit his right or her right to be a PW. Protection of prisoners of war. Prisoners of war or PW mentioned in Article 4 of Geneva Convention 3 or GC3 and Article 44 of Additional Protocol 1 or AP1 are entitled to special protection and treatment. Even though they may be interned without any particular reason, the purpose of such internment is not to punish them, but only to prevent them from taking part in hostilities. The protection by those regulations is a compromise between the interest of the detaining power and the PW. Prisoners of war are accorded this special status recognizing the fact that combatants are acting upon the interest of their country, and once they are out of combat, they are entitled to be protected. IHL provisions set out specific rules for the treatment of PWs. The GC3 143 articles require that PWs are treated humanely, adequately housed, and receive sufficient food, clothing and medical care. Its provisions also establish guidelines on labor, discipline, recreation and criminal trial. General protection of prisoners of war. It is to be understood that a PW is in the hands of the enemy power, but not of the individuals or military units who have captured them. Irrespective of the individual responsibilities that may exist, the detaining power is responsible for the treatment given to them. Article 12 GC3 very clearly mentions this. PW must at all times be humanely treated. Any unlawful act or omission by the detaining power causing death or seriously endangering the health of a PW in its custody, including subjecting to physical mutilation or to medical or scientific experiments of any kind which are not justified by the medical, dental or hospital treatment of the prisoner concerned and carried out in his interest is prohibited and will be regarded as a serious breach of IHL. Likewise, PW must at all times be protected, particularly against acts of violence or intimidation and against insults and public curiosity. Measures of reprisal against prisoners of war are prohibited under Article 13 of GC3. PWs are entitled in all circumstances to respect for their persons and their honor. Women shall be treated with all the regard due to their sex and shall in all cases benefit from treatment as favorable as that granted to men. PW shall retain the full civil capacity which they enjoyed at the time of their capture. The state detaining PW shall be bound to provide free of charge for their maintenance and the medical attention required by their state of health. All PWs shall be treated equally, irrespective of race, nationality, religious belief, political opinion, or any other distinction founded on similar criteria. Specific provisions for treatment of PWs in captivity. Every prisoner of war, when questioned on the subject, is bound to give only his surname, first name and rank, date of birth, and army, regimental, personal or serial number, or failing this, equivalent information. PWs who, owing to their physical or mental condition, are unable to state their identity shall be handed over to the medical service. No physical or mental torture or any other form of coercion may be inflicted on PW to secure from them information of any kind whatever. PW who refuses to answer may not be threatened, insulted, or exposed to any unpleasant or disadvantageous treatment of any kind. Officers and prisoners of equivalent status shall be treated with regard to their rank and age. Personal belongings of the PW shall remain in possession of the PW, including their metal helmets and gas masks and articles issued for personal protection. Only weapons including arms, military equipment and military documents can be confiscated from a PW. The detaining power may withdraw articles of value from PW only for reasons of security. When such articles are withdrawn, the procedure laid down for the sums of money impounded shall apply. The detaining power may restrict the liberty of movement of the PW within the perimeter of the PW camp. Prisoner of war may be partially or wholly released on parole or promise insofar as is allowed by the laws of the detaining power on which they depend. No PW may at any time be sent to or detained in areas where he or she may be exposed to the fire of the combat zone, nor may his or her presence be used to render certain points or areas immune from military operations. Prescribed conditions in PW camps. IHL prescribes that separate dormitories are provided for men as well as women with specified space per PW. Sufficient food and water, rations to be provided, and messing shall be in consultation with the PW themselves. Moreover, PWs should be allowed to prepare their food if they wish to do so. Clothing, underwear and footwear shall be supplied to prisoners of war in sufficient quantities by the detaining power, which shall make allowance for the climate of the region where the prisoners are detained. Uniforms of the enemy armed forces captured by the detaining power should, if suitable for the climate, be made available to clothe PW. Canteens shall be installed in the camps where PW may procure foodstuffs, soap, tobacco and ordinary articles for daily use. The tariff shall never be in excess of local market prices. The detaining power shall be bound to take all sanitary measures necessary to ensure the cleanliness and healthfulness of camps and to prevent epidemics. In any camp in which women PWs are accommodated, separate conveniences shall be provided for them. Every camp shall have an adequate medical facility where PW may have the attention they require as well as an appropriate diet. Isolation wards shall, if necessary, be set aside for cases of contagious or mental diseases. Specialist treatment facility should be provided to a PW when required, and all associated expenses relating to medical facility are to be provided by the detaining power. Medical inspections of PW shall be held at least once a month. PWs and labor conditions. The detaining power may utilize the labor of PW who are physically fit, taking into account their age, sex, rank and physical aptitude, and with a view particularly to maintaining them in a good state of physical and mental health. Besides work connected with camp administration, installation or maintenance, PW may be compelled to do so only such work which is not military in character or purpose. PW must be granted suitable working conditions, especially as regards accommodation, food, clothing and equipment. Such conditions shall not be inferior to those enjoyed by nationals of the detaining power employed in similar work. Account shall also be taken of climatic conditions. Conditions of labour shall in no case be rendered more arduous by disciplinary measures. Unless he or she is a volunteer, no PW may be employed on labour which is of an unhealthy or dangerous nature, like the removal of mines or similar devices. No PW shall be assigned to labour which would be looked upon as humiliating for a member of the detaining power's own forces. The duration of the daily labour of PW, including the time of the journey to and fro, shall not be excessive and must in no case exceed that permitted for civilian workers in the district who are nationals of the detaining power and employed in the same work. Transmission of information and monitoring. Geneva Convention 3 requires that a central prisoners of war information agency shall be created in a neutral country. The International Committee of the Red Cross shall, if it deems necessary, propose to the powers concerned the organization of such an agency. The function of the agency shall be to collect all the information it may obtain through official or private channels respecting prisoners of war and to transmit it as rapidly as possible to the country of origin of the prisoners of war or to the power on which they depend. It shall receive from the parties to the conflict all facilities for effecting such transmissions. Immediately upon capture or not more than 1 week after arrival at a camp, even if it is a transit camp, likewise in case of sickness or transfer to hospital or another camp, every PW shall be enabled to write directly to his or her family through the Central Prisoners of War Agency provided for under GC3 as just mentioned. Upon the outbreak of a conflict and in all cases of occupation, each of the parties to the conflict shall institute an official information bureau for PWs who are in its power. Neutral or non-belligerent powers who may have received within their territory a PW referred to in Article 4 of AP1 shall take the same action with respect to such persons. Within the shortest possible period, each of the parties to the conflict shall give its bureau the information regarding any enemy person who is a PW and has fallen into its power. Neutral or non-belligerent powers shall take the same action with regard to persons belonging to such categories whom they have received within their territory. The Bureau shall immediately forward such information by the most rapid means to the powers concerned through the intermediary of the protecting powers and likewise of the central agency provided. If an escaped PW is recaptured, the power on which he or she depends shall be notified thereof through the official information bureau for PW as mentioned above. Likewise, in any case in which the detaining power has decided to institute judicial proceedings against a PW, it shall notify the protecting power. A protecting power is a state instructed by another state known as the power of origin to safeguard its interests and those of its nationals in relation to a third power known as the detaining power as soon as possible and at least 3 weeks before the opening of the trial. This period of 3 weeks shall run from the day on which such notification reaches the protecting power at the address previously indicated by the latter to the detaining power. Likewise, any judgment and sentence pronounced upon a PW shall be immediately reported to the protecting power in the form of a summary communication, which shall also indicate whether he or she has the right of appeal with a view to the quashing of the sentence or the reopening of the trial. Furthermore, if a PW is finally convicted or if a sentence pronounced on a PW in the first instance is a death sentence, the detaining power shall as soon as possible address the protecting power at the request of the PW, and in all cases after death, the will executed by the PW shall be transmitted without delay to the protecting power. A certified copy shall be sent to the central agency. Death certificates in the form of annexed to the present convention or lists certified by a responsible officer of all persons who die as PW shall be forwarded as early as possible to the PW Information Bureau established under GC3. Monitoring. Representatives or delegates of the protecting powers shall have permission to go to all places where PW may be, particularly to places of internment, imprisonment and labour, and shall have access to all premises occupied by PW. They shall also be allowed to go to the places of departure, passage and arrival of prisoners who are being transferred. They shall be able to interview the prisoners, and in particular the prisoners' representatives, without witnesses, either personally or through an interpreter. Representatives and delegates of the protecting powers shall have full liberty to select the places they wish to visit. The duration and frequency of the visits shall not be restricted. Visits may not be prohibited except for reasons of imperative military necessity, and then only as an exceptional and temporary measure. The detaining power and the power on which the PW depends may agree, if necessary, that compatriots of the PWs be permitted to participate in the visits. The delegates of the International Committee of the Red Cross shall enjoy the same prerogatives. The appointment of such delegates shall be submitted to the approval of the power detaining the prisoners of war to be visited. Repatriation of prisoners of war. As PWs are only detained to restrain them from taking part in hostilities, they have to be released and repatriated when they are unable to participate. That is, during the conflict for health reasons and as soon as active hostilities have ended. Under the influence of human rights law and refugee law, those fearing persecution may not be forcibly repatriated. A prisoner of war who freely expresses his or her objection will not be repatriated, loses prisoner of war status and becomes a civilian who remains protected under Geneva Convention 4 until resettlement. This should be all for the lecture today. Let us meet again with another interesting aspect of humanitarian law. Till then, take care and bye for now.